Good morning, everybody. I know that the presentation is titled Data Privacy in the Social Media Age, but as all of you know, especially because you're in the cybersecurity space, social media is now used as a means to perpetrate many different types of cybersecurity attacks. And so it's important to talk about what some of those vectors might look like, but also in addition to that, what are some of the litigation trends? I'm an attorney, I'm the token attorney today, and so it's my job to scare you about all the different things that are happening in terms of the lawsuits that we're seeing in this space. So with that, let's level set. What is social media? It's a trick question. The answer, as many lawyers like to say, is it depends. It depends on the laws that you're looking at. It depends on the purpose for which you're defining the term. But let's start with common sources that we tend to look at. Merriam-Webster Dictionary, of course, defines it. Black's Law Dictionary is a dictionary that's used by lawyers when determining what otherwise commonly used terms might mean. And you'll see that the difference is stark, right? The Merriam-Webster Dictionary definition is much more specific. It talks about creating online communities. It talks about exchanging information and sharing information. Notably, it doesn't talk about creating that information. Although some legal definitions will also include that. Black's Law Dictionary, on the other hand, much more streamlined, but by streamlining it also makes the definition that much broader. You'll see that it's any cell phone or internet-based tools and applications that can be used to share and distribute information. And it uses or cites various examples such as Facebook, Twitter, YouTube, and blogs, which we're all familiar with. Next, you'll see in the next series of slides, I wanted to highlight just the different definitions as they're set forth in the law, mainly to identify the differences in the ways that social media is defined and determined by the courts. In this law, this is the National Science Foundation's law that governs the support for research regarding human trafficking. And you'll see social media platform is defined as a website or internet medium that allows users to do certain things. Create a user account, create lists and curate lists of other users with which or with whom they're going to interact. It also enables one or more users to generate content. Now you're seeing the generate language, which we did not see before, and then also primarily serves as a medium for users to interact with content generated by other users in the same medium. These two laws, if you are in compliance at all in your companies, are laws that you might be familiar with. The Communications Decency Act, or Section 230, is a federal law that governs circumstances where social media providers, which by the way can include employers, are excused from being held liable for content that they might allow to be shared on their platforms. You'll notice that the term social media is not actually defined in this law, even though presumably that is the type of activity or service that this law seeks to regulate. Instead, it defines internet, interactive computer service, and information content provider, and access software provider. Essentially, if a company provides a service or systems or an ability to access certain accounts that are connected through the internet, or allows a user to curate or summarize or otherwise compile various types of information that could qualify as being subject to this law. Note that this definition includes the typical Google, Meta, and those types of companies, but it can also include university libraries or similar services. It can also include employers. How many of you have intranets that are accessible to your employees at your organization? Great. So there are a few of you. So that can also qualify under this law. The Children's Online Privacy Protection Rule is a federal law that protects individuals under the age of 13. There are various laws that protect other individuals in varying ages under the age of 18, but this is the one that we have seen the Federal Trade Commission enforce consistently throughout the years. Essentially, it requires companies that operate websites or online service platforms to provide certain privacy notices, obtain permission from guardians or parents before children's data can be collected or processed, and also permits certain data subject rights, such as a data subject making a request that their data be deleted or that their data no longer be used. Very similar data subject rights that we're seeing under other laws like the California Consumer Privacy Law and the GDPR, for those of you who are familiar with those other laws. Interestingly, again, COPPA does not define the term social media. Instead, it defines internet and mixed audience website or online service. This is all to say that you might not realize that you're subject to certain laws because you might not realize that you're operating what could be defined or interpreted or deemed by a court or regulator as a social media platform. So if you are an employer or service provider that is providing a means for users to communicate with each other, share information with each other, or generate content, that might be sufficient for you to become subject to these laws and regulations. More social media definitions. California is at the forefront of many of the data privacy and security regulations in recent history. One of the laws that they passed is content moderation requirements for service providers on the internet. And actually, when this law was first passed, it was much broader. It actually required content moderation. Such that internet service providers and website or platform providers were required to take a look at what content is being shared on their platforms and actually regulate that and remove or delete or restrict certain content that could be viewed as either violating laws or could be viewed as offensive by particular users. There was some litigation, and after that litigation, the scope of this law was much narrower. What remains, however, is that even though content need not be moderated any longer, terms and conditions and certain information in the terms and conditions need to be included, as well as reporting to the California Attorney General at least twice a year with respect to what changes or what updates might have been included in their terms and conditions. Note that it's not enough for a platform to provide a means for individuals to communicate directly with one another, for it to qualify as social media under this law. That's different from the other laws that we've already discussed and that we've seen. What's interesting here is that even if you are not conducting business in California, if you have users that are using your platform and you meet the annual revenue threshold, you might still be subject to this law. So that's the other reason that I wanted to cite this law, to just point out that if you are conducting business in a particular state or particular jurisdiction, it's not enough to look at the laws in that jurisdiction. The same is true for COPPA, the children's law that we talked about earlier. Even if you might not have a platform that you view as directed towards children, if you are aware that the platform is being used by individuals under the age of 13, you could be subject to that law. In fact, ByteDance, that owned TikTok, was subject to regulatory enforcement actions and litigation years and years ago. How many of you have used TikTok or have seen TikTok? It's okay, you can admit it. So TikTok, of course, is a platform that allows the sharing and the generation of short videos, usually set to music. And when it first came onto the scene, ByteDance said, this is not really intended for children. It's intended for adults, of course. But as people started signing up for the service, it became readily apparent that the people using that platform were largely children. And it also became largely apparent that ByteDance was aware that children were the primary users of that platform. And so even though under COPPA, a service provider that is providing an internet platform, a social media platform, might not be subject to that law if that service is not intended for children. If the company is aware that children are using that platform, they might still end up being subject to the law. This slide shows you a list of various social media platforms, and you'll see the typical ones that we know about and that we typically consider social media. Facebook or Meta, YouTube, Instagram, TikTok, LinkedIn. But you'll also see that there are some messaging apps that you might not traditionally consider as social media, but are considered social media under many of these laws and regulations, in part because you are permitted to create an online social community on these apps. You can create, for example, chat groups and other types of groups And on those chats, you can then share information and create content, et cetera. And so therefore, it transforms those groups and that messaging platform into a means to share information through your community. All right, so what are some of the various concerns for social media companies? And I mentioned this, and it's directed at social media companies because they're largely the ones that are being sued. But note that if you are a business that has a website or has an application or has social media presence, these considerations and these risks might also apply to you by virtue of your relationship or use of those platforms. In fact, we're seeing that many of the lawsuits that are brought by individuals are not brought against Meta or Google, because they recognize that those companies have unlimited resources and have a lot of lawyers and a lot of manpower and incentive to fight those lawsuits. Instead, they're going after the regional companies, the smaller companies, the companies that are not in as good a position to defend against those claims. But the claims are rooted in the relationship of those companies with social media platforms. So what do I mean? There are some claims that are based on written law, based on statute, and you'll see that listed in the first half of this slide. Unauthorized access to computer data, which is also known as the Computer Fraud and Abuse Act. This law basically restricts or prohibits the unauthorized access or use of any computer device that's connected to the internet. I say that there are certain limitations to that, of course, but generally speaking, all computer devices that are connected to the internet, whether it's owned by the government or a private employer, might be subject to this law. And if an individual uses that computer in an unauthorized way, they could be subject to both criminal prosecution and also civil enforcement actions under this law. This law is actually used by some employers against their own employees when the employees exceed the scope of their employment or use another user's login information in order to gain access to certain data. What's interesting, though, is the Supreme Court in 2021, in a case called Van Buren, limited the scope of CAFA. There was a police officer in Van Buren in Georgia, and he was taking bribes to look up certain information about people's license plate numbers and other information on the police database. He was prosecuted. He appealed his prosecution, went all the way up to the Supreme Court, and the Supreme Court said, well, he technically was allowed to access that database. He didn't use it for the proper purpose, and for that reason, it's an unauthorized access. But that's not the kind of access that this law is intended to curb. And so we're seeing now the trickle-down effect of that Supreme Court decision, because before that, many of the prosecutions involving CAFA focused on not just physical intrusion into a device, but also exceeding the scope of permitted access within a device or within databases. Unfair competition is another one. If you have any privacy policies or terms and conditions, be careful what you put on there, or if you have any contracts with your users, because whatever you put in there can be considered representation that you can be held to, meaning the Federal Trade Commission, for example, looks at those documents and says, you promised that you were going to do certain things, and you didn't do those things, and as a result, a data breach occurred, and now these people's personal information has been compromised. And so now, even though you might not have had to do those things under the law, because you put out statements and representations to the public that you were going to do those security measures, or you were going to implement those security measures, now you're held to that higher standard. Because at the end of the day, consumers should have been allowed to make a decision whether to use your platform, to use your company, or another company. And part of that decision-making process is based on the publicly available statements that you've made. And so I know that in many companies, the PR or marketing teams decide what to include in those statements. Just make sure that your compliance and legal teams review those as well, because they could expand the scope of your obligations under the law and can open you up to certain liabilities. Certain states also have invasion of privacy laws that have resulted in claims against organizations. We'll talk a little bit about that in greater detail. And then, of course, there is another set of claims not based on written laws, but rather based on what our courts view to be equitable or fair under the circumstances. So even if there's no law that says certain things are prohibited, a court might say, it would not be fair if we were to determine that an individual can't make a claim against a company because there's no law that has been passed by the legislature. And so in these cases, invasion of privacy is one. If you are tracking the activities of a user on your website or on your application and you didn't get consent, you didn't provide sufficient notice, that could result in a claim against the organization. Trespass is another one. So if your company is publicly scraping certain websites and that public scraping is slowing down or impacting the performance of the relevant server, that could result in a claim that you've trespassed against the property of that third party. The same is true if you do anything that might impact the performance of a server. So, for example, if you are saving pixels or other tracking technologies that then slow down the performance of that server. Conversion is another one. So, how many of you have social media accounts for your organizations or run social media accounts for organizations? I see hands in the back. Yeah. So, there have been a lot of cases related to who owns those social media accounts. And there was a recent case in the Southern District, which is a New York court, that went against the grain of the other case law that we've seen in this space. Typically, courts will look at a few different factors when determining whether an individual or a company or an individual or a company owns a social media account. So one of the things they look at is, did this social media account link to the official website or the official accounts of the company? Did the social media account post largely work-related matters? Were the logins for the social media account shared with other employees of the company, not just the individual user who might have been primarily responsible or who might have created the account? And were those other employees also sharing information on the social media account? Depending on the answer to those questions and some other questions, a court might say, the social media account is owned by the company, even though an individual might have started that account themselves. In the most recent case out of the New York federal court, it went kind of in a different way. There was an employee that entered into an agreement with JLM Couture. They agreed that they would design a bridal wear line. As part of that effort, this individual used their own personal information to open and create a social media account. They posted the designs on that account. They posted information about the collaboration. They posted a lot of company-related information on that account. When they tried to renegotiate the contract, they couldn't agree on the terms of that agreement, and so they severed ties. The company said, well, I'm going to sue you for conversion. Conversion means you're taking my property and using it as your own. Because this is really my account, my company account, that now you're using as your own personal account. You only got your followers and your engagement because of the company content, and now I'm going to miss out on that value because you, individual, are going to take the social media account with you. And the court said, well, let's look at a few. We don't need to do the multi-factor test. We just need to look at a couple of things. One is, who opened the account? Was the account opened using company information, or was it opened using the individual's personal information? If it was opened using the person's personal information, then it's more likely a personal account than not, irrespective of what you're sharing on that social media account. The next question then becomes, was there a transfer of the rights to that social media account by contract or some other agreement? So the court looked at the employment agreement between the designer and the company, and there was a provision in there that I'm sure many of you are familiar with. It's a non-compete, and there's also a provision that says certain work product that you create during the time of your employment with us is owned by the company. But the court found that the social media account fell outside of that scope, that this was not work product in the same way that that term has been interpreted historically or that the parties intended in this agreement. And then, as a result of that, the court also found there was no transfer of this personal account to the company. And so it's important for those of you who have these social media accounts that you create a clear delineation between what your employees' accounts are and what your company accounts are. And be careful about going the easy route and using personal information when setting up these accounts, because you might lose your rights to those accounts, especially in New York, or if your company is subject to the laws of New York. Breach of contract is another one. I mentioned this earlier. Your terms and conditions and your privacy policies can create a contract between you and your users, including your employees. So be very careful what you put in there. Don't put anything more than what you absolutely have to. And then the last is unjust enrichment. And unjust enrichment essentially means you, company, are benefiting from something of value to me, and you're not paying me in exchange for that thing of value that you're taking. And in many circumstances, this includes the personal information that companies are collecting of individuals when those individuals use their websites, social media accounts, their platforms, or their applications. So here are some laws that regulate social media activity. How many of you heard about CIPA, C-I-P-A? Yeah, I see some hands being raised. Just in since 2022, there have been over 2,500 lawsuits that have been filed that claim a violation of this law. And many of those lawsuits are not brought in California or not brought against solely California-based companies. CIPA was a law that was put in place in 1967. Kind of during the time of the Cold War. And it was really intended to be an anti-wiretapping law. And when you think anti-wiretapping, it is what it sounds like. It means that there is a third party who is tapping into your phone communications, and that was extended to email communications, to see what it is that you're talking about and who you're talking to about those topics. That now is seeking to be extended by certain lawyers to say, look, that really also applies to any information that's intercepted in connection with a website. So when you go on a website, many websites use cookies or other tracking technologies to track certain things, such as what geolocation you're coming from, where you're visiting the website from, what IP address you're using in order to visit the website, what type of machine or device are you using to visit the website. They even track what search terms you use when you are searching for content on the website, what links or web pages you are clicking on, what information you are disclosing, for example, if you're filling out any forms, things like what you're putting in your shopping cart. And so there's a lot of information that can be obtained through websites. And in many circumstances, companies use that for their own purposes, for security purposes, right? To see if there's an attack so you can trace where that attack might have originated, to block certain types of attacks before it begins by limiting how people can access your website, particularly from suspicious locations or IP addresses. It can also be functional. I mentioned earlier that some cookies are used to determine what items did you add in your cart. Because how annoying would it be if every time you had to buy an item, you had to check out because the website couldn't remember that you wanted to add more than one item into your cart. The struggle now is that there are plaintiffs' law firms, and you can tell I'm a defense attorney in large part, there are plaintiffs' law firms that are seeking to expand this law beyond its intended meaning. They're saying, if a company is allowing a third party to collect that back-end metadata without obtaining the consent of an individual user, then that violates this law and violates other federal wiretapping laws. And they're saying that because they're equating the metadata that I just mentioned to communications as defined under this law. And we've seen kind of a difference in decisions from courts around the country. Some courts have agreed that there's enough content in that type of data to qualify as violating this law, while some courts have said that's not really communication, because you're not communicating with anyone, you're not saying anything of substance to anybody when you're conducting searches on a website. Instead, you're just conducting searches. And this really started because in 2020, the Health and Human Services that enforces HIPAA. HIPAA is the privacy law that governs certain healthcare providers and health insurance companies and databases that allows for the processing of claims. In 2020, HHS put out a guidance that said, if a patient visits your website, covered entity under HIPAA, hospital system or healthcare provider, and you collect that information, what search terms they're using, what doctors they're looking at, what articles they're viewing on your website, even if you're not asking them to identify themselves using a combination of a username or password, that qualifies as protected health information. And of course, that expands the meaning of HIPAA quite significantly. There's since been case law just this year that decided that that was an unlawful expansion of the law, but nonetheless, these lawsuits are seeking to expand these laws in ways that were not contemplated when these laws were initially put forward. Another example is the Video Privacy Act. How many of you remember Justice Bork? He was a Supreme Court Justice nominee, I think in the early 90s. People are calling me, you're shaking your head. Late 80s. So the law was passed in the early 90s, which is why I thought Bork was a nominee in the 90s. So when Bork was the Supreme Court nominee, I'm not sure if any of you remember, his video rental history was published by a newspaper. And this law was passed in response to that because this law says, well, that's personal information. And you really shouldn't be allowed to disclose that without the permission of the individual user. But at the time, it was geared towards brick and mortar stores, the Blockbusters of the world, and places where you can actually rent a VHS tape or a Betamax tape. And now plaintiffs' attorneys are seeking to expand the meaning of this law to extend not only to the Netflixes and the Amazon Primes and other video streaming services of the world, but if you're a company that shows short videos or videos on your websites, videos on your applications or your social media accounts, you can also be, according to these attorneys, subject to claims relating to the Video Privacy Act. And by that I mean if you are allowing advertisers or even Meta or Google to collect the information or see the information that you're collecting in connection with viewing that video, then technically under the law, the argument is that you're sharing that information to a third party without the permission of the user. And so those are some of the things to watch out for. The California Consumer Privacy Act, or CCPA, is a law that we know is one of the most comprehensive data privacy laws on a state level in the United States. Again, it could apply even if you're not doing business physically in California, if you meet certain of the threshold requirements. I wanted to just note that in July of this year, the California Attorney General announced their highest or largest settlement pursuant to the CCPA to date. They settled for $1.5 million with a company called Healthline. It's a wellness and health website, and it is one of the 40 most visited websites around the world. And apparently they were using cookie banners that ostensibly allowed users to decline certain tracking of their information, but it didn't actually work. You would select that you didn't want your information to be collected, and yet they were collecting it anyway. They were just making you feel better, I suppose, by showing the cookie banner. They were also accused of sharing information with third parties without contracts with those third parties, including advertising agencies that allowed targeted advertisements to be shown to their users. And they also did not impose any they did not comply with their obligations to protect the data under the law. And so that's just to say that we're talking about social media and the risks that are associated with your use of social media or running a social media platform. And that term is broadly defined, as we mentioned. But also, these other laws don't go away just because we're focused on those kind of more specific social media targeted laws. So make sure that you're keeping those in mind. So the Communications Decency Act I mentioned earlier immunizes online service platforms from certain claims. Basically, if back in the day before the internet came into being, if you were a book publisher, you were immunized from claims that an author's content in a book was defamatory or was illegal in some way. The courts recognize that as a publisher, you're not responsible for what somebody else says. You are just publishing and distributing this material. When the internet came into being, there were two lawsuits that were brought against CompuServe and Prodigy. They were providing blogging services. And Prodigy basically took the position that they'll moderate some of the content. They'll remove some of the offensive content, retain some of the content that they deem to not be offensive. And on the other hand, CompuServe took a no moderation position. They said, we're not gonna moderate anything. It's a free for all, it's a free country. We're gonna let you say whatever you want. This law came into effect because they wanted to encourage the internet service providers to moderate content. And so if an internet service provider voluntarily moderates content, they were immunized from claims relating to that moderation. The legislature also wanted to expand the use of internet-based services. And so this law was also intended to encourage these companies to expand their services and to provide their services to more people. And so those companies were also immunized from content that individual users might put out on their platform. Because otherwise, of course, if they had to be subject to a lawsuit every time somebody said something that was defamatory or offensive in some way, they could go out of business, and then we would have no social media platforms. There are exceptions to that, and so there is an obligation to remove content that violates intellectual property, so copyright, trademark, trade secret, that kind of thing. Things that relate to human trafficking are also subject to regulation and should be regulated. And also there's an exception if the company itself is putting out its own content, they're not immunized from liability as a result of that content. They're only immunized if some other third party put out that content. I'm just gonna talk a little bit about some of the cases that we've seen that might be of interest and ways in which different parties have tried to get around Section 230's immunity. So in Doe versus Grindr, there was a teenager. He was 15 years old when he started using this dating app. And he used it primarily when he's at school. And he was connected and matched with a lot of adults. And in fact, over a course of 4 days, he was raped by 4 different adults. And he sued Grindr, and Grindr said, well, 230 immunizes us because that's not our fault that there's content on there and there are users that are abusive. And the court essentially said, you know, actually, John Doe is permitted to pursue this claim because he's not suing you because of your content or the content that's posted on the platform. He's suing you because of your product design. And by that, they argued there's no age verification that was conducted before this person was allowed to use the platform. Also, there was no geofencing. The fact that he was at a high school or in middle school at the time that he started using the platform and he was being connected to adults that were within 100 yards of that school was also problematic. Carson, the estate of Carson Bride versus YOLO Technologies is another one in which, again, it was the design of the platform that the plaintiff took issue with. In this case, there was an individual, a kid, who was bullied relentlessly on this platform. The platform's claim to fame was they represented that they would agree to take down offending user accounts and offending content if users complained. In this case, the teen's parents complained multiple times and the platform did nothing about it. And so the lawsuit and the person ended up committing suicide, and the lawsuit centers around that design and that representation. And as a result of that, the court also said, this is not immunized pursuant to Section 230. And last but not the least, Bogard versus TikTok, Inc. This is a products liability case. There was a YouTube trend where people were encouraged to participate in the choking challenge. And this is children were encouraged to choke themselves using belts and other implements until they passed out. And many children were doing this alone, without supervision, without anybody else around them, and resulting in injury or death. And in this case, the complaint was, look, we're not complaining about the content, the fact that there are choking challenges on your platform. What we're complaining about is you knew there were choking challenges, you knew that this was harmful, and you didn't do anything to prevent that dissemination of that information. On top of that, your algorithm was actively pushing this content to people who were underage, to people who were vulnerable. And as a result of that, we suffered an injury, and therefore the immunity should not apply. So those are some of the ways in which plaintiffs are getting around this immunity prohibition. Contract claims is another one, similar to what I mentioned before about terms and conditions and privacy policies. If you make a representation you're going to do something and you don't do it, then that could be problematic, and now you have a breach of contract claim on your hands. In this case, Khalees versus Meta Platform, there were third-party advertisers that advertised certain jobs. It turned out to be a human trafficking scam. And the Meta said, well, we shouldn't be liable because we're not responsible for the content that these third-party advertisers put out on our platform. And the court said, well, we're going to allow this claim to proceed because you did a couple of things. One, you actively encourage these advertisers, to advertise on your platform. Two, you were informed that there was an issue with these advertisers and you didn't do anything. You didn't warn your users, you didn't pull the content, and you didn't regulate to whom the algorithm would push this content to. The YOLO one is the one that we talked about already, where the company said, we're going to take down problematic users, and they just refused to do it and failed to do it. Interestingly, in Anderson versus TikTok, there was a 9-year-old girl that participated in the Blackout Challenge, and the court also in that case said algorithm and the fact that the algorithm acts a certain way is not covered by the immunity of Section 230. Because again, the plaintiff is not challenging the content of what people are saying on your platform. What they're challenging is your actual algorithm, the way that works on your platform. So what are some of the data security considerations for employers and employees using social media? We already talked a little bit about ownership of certain social media accounts, right? Making sure that you lock that down, that you regulate that, because it can be used in social engineering scams, and it could be subject to hacking, which can then expose your company and your employees and customers to attacks, and so be careful about that. But also corporate use of your social media. We have many clients that we're seeing now that are fighting against impersonators. And so be vigilant and look at your online presence, because there are many companies that fall victim to the scam without even realizing it. The same is true for websites. And we see this especially around the holidays when people are shopping online and they're much more easily encouraged to participate or to make purchases on websites and social media platforms. There are a few different types of phishing attacks that I wanted to touch on. The Democratic National Party in 2016, some of you might have heard about that. John Podesta was one of the targets of that spear phishing. And of course, spear phishing means it's a phishing attack, but it's targeted at a big whale. It's targeted at a particular individual. In this case, people who worked on the Hillary Clinton campaign years prior to this happening were publicly available, including some of their email addresses. And so the bad actors targeted those individuals, pretended that they were somebody who those people expected to hear from because they knew that those people worked together on the campaign, and then tricked them into disclosing personal information. Including in John Podesta's case, he was actually sent a Google link where he was told that there was a security issue. Please use this link to reset your account. He actually did the right thing. He forwarded it to IT. And the IT response to the email contained a typo. Instead of saying, do not click on the link, or this is not a legitimate link, it instead said it did not contain the word not. And so he clicked on the link, he changed his password, and of course, the rest, as they say, is history. In July 2020, there was a big Bitcoin scam targeting Twitter employees' Slack channel, and they ended up compromising the accounts of really famous individuals, Elon Musk, Barack Obama. Apparently, especially during the pandemic, there was a Slack channel that had at least 1,500 employees and contractors of Twitter, now X. And pinned to the top of that channel were documents explaining how to gain access to user accounts from an administrative perspective. These bad actors, using LinkedIn and Twitter and other social media platforms, identified the people who are most likely to have access to that Slack channel, and then conducted a phishing attack that then allowed them to infiltrate the Slack channel. And once they did that, they were able to then go and take over these famous people's accounts, and they posted messages saying, if you send a certain amount of Bitcoin to this wallet, you're guaranteed a rate of return of twice the amount that you send by this time. And of course, because they were tweeting from really respected individuals' accounts, they gained a lot of traction and were able to collect hundreds of thousands of dollars worth of Bitcoin in a matter of hours. Of course, romance scams is another one where people pretend to be potential romantic partners and convince people to give money, resources, credentials, and other resources. Let's see if this will work. This is easily actually findable online if you are so inclined. You'll see, oh, maybe it will work now. Somebody's helping me out in the back.
Malarkey. We know the value of voting Democratic when our votes count. It's important that you save your vote for the November election. We'll need your help in electing Democrats up and down the ticket. Voting this Tuesday only enables the Republicans in their... What a bunch of malarkey.
That's okay. So this is actually just on the MSNBC website. During the primaries, these last election, there was a robocall that went out pretending to be President Biden, telling the Democrats not to come out to vote during the primaries. He said, you know, you really need to save your votes for the general election. We don't want you to waste your efforts now, so don't worry about it. And it was actually quite successful in suppressing the votes. And so what's important here is that you need to train your employees, and you yourself have to be aware of what types of attacks are happening, because it helps you become more aware and be more protective of your own organization. I wanted to also share with you, and we're talking about social engineering and publicly available information about employees and relationship among individuals. LinkedIn is a good source for that. It's a source that many bad actors use. And this is the rate of the fake profiles that LinkedIn reports they have removed. And you'll see a significant increase in the number since 2019. The 2024 numbers are not here, but I'll tell you what they are. In 2024, LinkedIn said they removed 156 million fraudulent profiles on LinkedIn. 56 million, which is significantly more than even the 80 million in 2022. That's a 29% increase from 2023, and 70.1 million of those were blocked in the first half of 2024, which is up from 46.3 million from the second half of 2023. So we're seeing a significant rise. And in fact, many of you might not realize this, but you might be connected to colleagues on LinkedIn that have more than one account. Before accepting accounts, you really should be discerning as to who those accounts are and if they're legitimate, because what happens once you're connected to them, you're lending your own credibility to those accounts, and that can then be used by bad actors to perpetrate attacks, maybe not against your own organization, but against other organizations. So here are some ethical and professional considerations for those of you just who are lawyers who are in the audience, but also if you're litigating, and it's good for you to know that lawyers and their agents are not actually permitted to gain access to individuals' personal social media accounts without disclosing that they're lawyers and the purpose for which they seek to connect with that individual. So if somebody tries to connect with a witness or a juror, that's not permitted, especially if they're not disclosing who they are, but publicly available information is fair game. So if your account is not locked down, then that information can be used, can be collected by lawyers and their agents. Note that communication is the key. Lawyers are not permitted to communicate with witnesses or adversaries or jurors, and in this case, the bar was looking at, well, what does communication mean? What if I'm on LinkedIn and I looked at somebody's profile and there was a notice that was sent to the user that I looked at their profile? Is that communication? Pursuant to the American Bar Association's guidance, they say it's not communication because you're not doing anything affirmatively to push out a particular message to that individual. The notice happens as an automated function of that website. But depending on the particular jurisdiction, that can change. So something to be mindful of. Here's another one for judges. You might be wondering why judges don't have social media presence or they're using social media in a very limited way, and the reason is because they have even more specific restrictions with the way they can use social media. For some of you who follow publicly available or publicly covered litigation or trials, you might be wondering, well, what are the restrictions of lawyers in terms of putting content out on social media? Technically, lawyers are not permitted to put information out on social media about their ongoing cases. In fact, even after cases are resolved, we're technically not permitted to do that without consent from our clients. But even if we have consent, sometimes it's unethical to do that if you're influencing or could influence the outcome of a case. There are certain exceptions. For example, how many of you are following the Justin Baldoni and Blake Lively litigation? I'm endlessly fascinated. I should have just done my entire presentation on that litigation. I'm going to do celebrity litigations maybe next time, but it's fascinating to me because the lawyer for Justin Baldoni is always on social media, is always being interviewed by the press, and I always wondered how can they get around the restrictions against lawyers doing this. And one of the things that lawyers tend to do to justify it is to say, look, I'm only correcting the public record. There's already bad information about my client out there, and it is my professional obligation to correct that misinformation, and I'm doing that by giving these interviews and by responding to the press's inquiries. So there are a few different ways to get around it, but technically we're not really supposed to be engaging in that kind of activity. Wanted to just mention quickly emerging issues, dark patterns in marketing. So if you have websites, social media apps, or mobile applications, if you engage in any practice that makes it difficult for a user to unfollow you, to opt out of certain collection of their information or certain products, or if your design makes it so confusing, then you could be subject to enforcement actions by the Federal Trade Commission. And they announced 2 years ago or a year ago that they were going to start doing this, and we've seen since then significant activity on this front. So be careful about your design. Make sure that the fonts and the buttons and all of the different things that you are providing to your consumers are easily identifiable, and that you're not either prohibiting them from exercising their rights or making it confusing for them, or using kind of tactics, psychological tactics in order to encourage them to take certain action. Encouraging them to sign up for your service, make payment, or add their names to your marketing list, etc., because it could be seen as misleading. All right, so here are some of the other emerging issues. We're seeing a lot of claims that certain companies are monopolizing these types of services. Meta is one, for example, especially because they acquired Instagram, WhatsApp, etc. We're seeing facial recognition laws as well, and litigation involving facial recognition propagate, and then also consolidation of data sources, a lot of public scraping, and many of the laws that we're seeing now are prohibiting public scraping or using information for a purpose other than the original purpose for which the information was collected. All right, so with that, does anyone have any questions?